Okay, so let me start saying that this is the 10th EMFA talk that we are doing. We have started at the beginning of the year. We had more than 40 speakers and more than 600 online participants, and we have already discussed Article 3, 4, 5, 6, 18, 22, and now 24 and 25 of the EMFA. Obviously, we come back also to certain articles because the situation evolves and things happen, and so it's important to go back. Our idea is that these EMFA talks will follow the EMFA application in the next couple of years, trying to really get all the information and all the reflection that are possible on the EMFA evolution. Also, we are interested in the interplay between EMFA and the other regulations. For example, today the interplay with the DMA is important, but also the interplay with the Digital Services Act normally is at the core of the discussion. Let me say that also we are publishing, not necessarily out of this, but often out of this discussion, also this blog post, so short opinions trying to consolidate the discussions and the thinking about the evolution of EMFA at this point. So you are welcome to propose blog posts also if you are interested. Okay, we have done several studies on EMFA. I don't want to spend time on those to save time. Let me say, however, one thing that is important for us, that we are making a major effort year after year, from last year and now this year, to integrate so-called EMFA variables in our flagship research activity, that is the Media Pluralism Monitor. So we are introducing the EMFA dimension more and more in the NPM, as is normal because the EMFA has become a standard for European pluralism and media freedom in Europe. We are now also running a study for the European Parliament, the CALT committee, on the implementation of the EMFA, but these kind of things will be continuous in the next years. Okay, let's move to the discussion of today. We have 3 speakers, Roberta Carlini from our team, I'm assistant professor at the UI, that will introduce the discussion of the Article 24. Then we have Roberto De Martino from the Italian Communication Regulatory Authority, AGCOM, that has been very active and particularly active on the EMFA Article 24 discussion, also at the European Board of the Service. And then we have Conor Murray that will tell us how the industry stands at this point from EGTA, International Trade Body for Multi-Platform Television and Audio Business. This discussion will be as usual. There will be introduction by the 3 speakers, then we'll open the floor and we'll have time for an open discussion. Clearly, the Article 24 is important, is a major effort of harmonization of something that is very important for media pluralism and for the media variability, that is understanding audience measurement, also in function of advertising, the value of the news, the value of the media, and so is one of the key steps that the EMFA is introducing in our discussion and in the future of the sector. But I don't want to spend more time on this introduction. I leave the floor to Roberta Carlini. Roberta.
Thank you, Pier Luigi, and thank you to all the participants for coming. And yes, I want just to present what the article is and what we have done. It is one of the most technical and difficult topics in this law. I want to give the context and to open the discussion in a way. This Article 24, it's in the section that is on transparent and fair allocation of economic resources. So it is important to see that there are two articles. I mean, transparent and fair allocation of economic resources in the media sector is a huge topic. These are two articles. This one is more on the private, on the market side, and the second article is on the state advertising. So all the intervention on the private market when it comes to the fair allocation of resources is audience. So what is audience measurement? I'll start with the definition of the EMFA, that is the audience measurement is the activity of collecting, interpreting, or otherwise processing data about the number and the characteristics of users of media services or users of content in online platform for the purposes of decision regarding advertising allocation, pricing, purchases or sales, or regarding the planning of distribution of content. So is data basically that covers all forms of media, ranging from television to radio, print news, online news, streaming services, and social media. And it's in a way the currency of the advertising, but we will see this better. What we know from our activity, our research on the Media Pluralism Monitor, that is the opacity of the market and of the audience measurement is a big issue from the researcher's point of view, and of course from the risks, from the point of view of the risks to market plurality, for the market to be accessible, and it is necessary that the information are distributed and accessible. What we know in the Media Pluralism Monitor, that is our project with which we assess the risks for media pluralism, we pose questions to the national researchers, and these two pies are about the percentage of an option to answer to this question is no data. We have no data to answer you. And in the average of the 200 questions of the monitor, we have 5% of no data answers. In the market area, it is 16%. And this is not because our researchers are not good in looking for data, but because there are not primary data, official data, reliable data. And this was already true for the traditional media in some countries, because not all the countries in the European Union and in the candidate countries developed transparent system out of self-regulation and standards of industry, but it is more and more true in the digital environment. I want also to add that as Pier Luigi was mentioning, we are introducing variables in the Media Pluralism Monitor to take into account the existence of this obligation, this new law, and these rules. So in next year, we will also assess the state of implementation of this Article 24. Why regulating audience measurement? Because, as I was saying, it has a direct impact on the allocation and prices of advertising. Because of the growing role of audience data also in the strategies of the media industry. I mean, from both sides of the problem, that is trying to improve the reach and the effectiveness of the advertising offer, but also to know better the audience, the media audience, to offer subscriptions or tailored products, to try to figure out a new business model in these times of this media disruption in the digital environment. In principle, I'm reading recital 69 that states that in principle audience measurement should be carried out in accordance with widely accepted industry self-regulatory mechanism. So it's a field of self-regulation, not of laws and regulatory intervention. However, a regulation is needed in the new environment because self-regulation isn't enough to provide audience measurement that are reliable, transparent, and accessible to everybody because of the new players that have emerged in the media ecosystem, such as online platforms, that do not abide to the industry standards or best practices agreed through relevant industry self-regulation mechanism and provide their proprietary measurement services. Basically, what Article 24 tries to do is to address imbalance of power in the not in general sense, but in the information asymmetry about the attention market, advertising market, and in general the audience, the role of the audience. Article 24 is two-folded. It poses seven general principles to which all the providers of audience measurement should abide, that are transparency, impartiality, inclusiveness, proportionality, non-discrimination, comparability, and verifiability. And then specific transparency obligation on the providers of proprietary audience measurement systems, so the new actors. And they have to share, basically the obligations is sharing detailed, comprehensive, intelligible, and up-to-date information on the methodology, and also providing an independent audit on this methodology. But point C, para 2 of Article 24, is also that they should make available at the request of a media service provider information on the results. So obligation to share methodology, but also some obligation about the results. And the second part of Article 24 is about the role of regulators in encouraging and fostering the adoption of codes of conduct by providers of audience measurement systems. In this case, both the media service providers, the providers of from the industry side, in media industry side, advertising and online platforms and any other interested parties. This role of regulators is at the European Union level, where implementation of Article 24 is entrusted to the Media Board, and it is a key priority for Work Group 3, which is chaired by the Italian regulator, AGCOM, that we have here today. And also, the Media Board will foster the exchange of best practices related to the deployment of audience measurement systems. So it is a role of, to incentivize a form of self-regulation and co-regulation. The Italian regulator started years ago, but in a recent decision in July 2025, it opened an investigation on the platform's audience measurement methodologies. So the challenges ahead in implementation of Article 24, which we should discuss today, we have the opportunity to discuss today and to hear to qualified players and regulators, is how to translate these high-level principles, the 7 principles of transparency, proportionality, etc., into concrete practice. Outline mechanisms for information sharing between the audience measurement providers, the advertisers, and the media service providers, developing the standards, and also the role of Media Board and national regulatory authorities. And I want also to add that some open questions we have ahead, that is, it is not just, even though the recital of the European Media Freedom Act and the article and the section in which the article is framed insist on the monetization of audience. So it is important to measure the audience, to monetize it, and to have a fair market. It is also the currency to monetize the content for the media content and the audience for other purposes that in the meantime are becoming more and more important, like the payments, the copyright payments for the generative AI systems, more generally to evaluate to assess the value of the news and the media content. It is also necessary having these shared and reliable systems to measure audience to effectively implement another article of the European Media Freedom Act, that is Article 22, because Article 22 very much insists on the fact that you have to assess when there is a media merger the impact on public opinion, and the impact of public opinion online. How do you assess the impact of public opinion online if you don't have a standardized and a reliable metric to measure the reach of media? Also, it is another open question is the interplay. Pier Luigi mentioned that the next EMFA talk will be about the interplay between European Media Freedom Act and the Digital Service Act. Here, for the sake of this article, there is an important field of interplay with the Digital Markets Act, and in particular with Article 6, Para 8 of Digital Markets Act about the data sharing obligations of the gatekeepers, the obligations about the advertising data that they have to share, they should share with when the publisher requests it. So this is these are the questions, and with this I open the floor to the discussion, starting with Roberto De Martino, who is the representative of the AGCOM, the Italian media regulator. I have to, okay, stop sharing. Thank you for your attention.
Yeah. Okay. Good morning. I am Roberto De Martino. I work for AGCOM, and recently we are focusing on the application of Article 24 of the EMFA regulation. We, as authority, then I will have a presentation on that. We have I would say, long experience in, I would say, audience measurement regulation, because the accounting law for AGCOM in 1997 included in one.
Sorry, Roberto, do you want to share your slides?
I was thinking to make a general introduction.
Okay.
No, if you want, because what I'm saying now, it's in the slide, so I can also start from the slides. Everything is.
No, just tell us when you want to share, and we will share your slides.
No, one question, because I am not familiar with Zoom, with this. Is it possible for you to share? I send my slides.
Yes, of course.
Okay.
Yes, in the meantime, you can go ahead.
Yes, and so in these activities, we actively participate in the working tree group of the EMFA board, where we have a particular work stream, I think it's work stream 1, which is relevant to Article 24. What we are doing in this group is we distributed a kind of survey to all NRAs which participate to this working group, just with the purpose to assess what is the situation among the various NRAs and each country in Europe, to see the common points, the differences, and also is, I would say, at a more developed stage, and who started just recently on this task. Then we had in October also a very interesting workshop in Brussels, where we met. We had 2 sessions, an internal session with just NRAs, the EMFA board, and the European Commission. And then we had the second session, which was open to all stakeholders from the market. So we had broadcaster, media providers, platforms, video on demand providers, association. We had several associations from different perspectives, where we get also some, I would say, some useful information, some results, because then we will have to prepare a kind of report which will be directed to the EMFA board, which will provide information on the status of audience measurement in Europe and what we think it would be necessary, what would be the next step for the application of Article 24 in the various member states.
Sorry, Roberto, I'm sharing the slides. Just tell me
okay. So
which slide I have to go to.
This part of the slides was already covered by the previous intervention, so I will go very fast on that. It's just a review of what is contained in the EMFA regulation. So it was already said that okay, if we can come back to the previous slide. Yeah. Okay, so what is audience measurement? Is collecting, interpreting, or otherwise processing data about the number and characteristic, so through different, because we know that there are different methodologies to measure these numbers, of users of media services or user content on online platforms. So this is related to, I would say, all the different means by which you can receive media content for the purpose of decisions regarding advertising allocation, pricing, and so on, for market and editorial purposes. Next slide, please. Okay, this definition covers measurement systems developed as agreed by industry standards within self-regulatory organizations, like, for example, the JIC, the Joint Industry Committees, and measurement systems which are out from the scheme, and they are developed so outside the self-regulatory approaches, and these measurement systems tend to be used by certain online players, online platforms that self-measure their audience or provide proprietary audience measurement systems to measure audience without abiding by agreed industry standard or best practices. Next slide, please. So we had two different, in the regulation, two different measurement systems were individuated. We have non-proprietary, where the data are insured by entities whose neutrality is guaranteed, and usually governance systems of these providers is based on the co-participation of different stakeholders like publishers and advertisers. Then we have proprietary measurement system, where the data produced by the same entity is based on metrics which are not shared and not subject to verification or regulated. And so these systems are used to self-measure the audience, in particular for online players like online platforms. You can see from this slide that we have, in our opinion, two different sectors for non-proprietary measurement system, like the GIC. In Italy, for example, we have Auditel, AudiWeb, and so on. In France, we have Médiamétrie, and so on. Then we have independent research companies which make part of this sector, like Kantar, Nielsen, Comscore, and so on. And then we have proprietary measurement systems which are proprietary, and they are used by usually online platforms like YouTube, Prime Video, Amazon, Netflix, and so on, to measure their own audience. Next slide, please. So we have some two functions for the tool of audience measurement: to have the concept of fairness, objectiveness, and timely assessment of content performance for a correct allocation of advertising investments. And audience quantifications is also a key tool for assessing the performance of media content and for understanding audience preferences and so on. Next slide, please. So these are again from some principles which are part of Recital 69 of EMFA, and where we talk about correct allocation of the advertising investment. Audience quantification is a key tool for assessing the performance of media content, and so on. Next slide, please. Okay, so as it already said, the first point of Article 24 is a kind of obligation for all providers, proprietary and non-proprietary, while the second and third point of Article 24 refer to principles which have to be adopted by proprietary measurement providers. We think that GIC, for example, they already comply by default to the principles of point 1 of Article 24 due to the, I would say, the structure and the governance model, which is based on the co-participation of publishers and advertisers, and also by the requisites of transparency, impartiality, and so on, which are intrinsically included in the principle of GIC. Next slide, please. One of the 7 principles that we think is a key is the principle of comparability of data. After, in my presentation, we will go on a, I would say, practical case that we tackled in 2022, because we had a case where DAZN and Auditel, they were publishing, or at least there were 2 different measurement systems, one by the EGCOM and one by, I would say, DAZN. And this data and also some, because in Italy, audience data, there is also a role in the football rights, because there are part of the income which is distributed to the different teams of Serie A, which are based on audience data. So we had to tackle this problem also from this point of view, because we had 2 different measurement systems, and as I will show you in the next slides, they were producing different results, so we have to tackle this problem. Okay, so this is the second point of the Article 24. This is an obligation, I would say, for platforms, for proprietary audience measurement systems. There is an obligation to disclose to media providers, advertisers, and several different stakeholders in the sector information on the methodology used by their measurement system. And they have also this, in point 3, another obligation, because they have to ensure the auditing. They have to be audited once, at least once per year, by an independent measurement provider. Next slide, please. Okay, then there is, I think it's point 4. This is a kind of obligation for NRAs. So NRAs shall encourage providers of audience measurement system to draw up codes of conduct to comply with codes of conduct which are jointly agreed. So I would say this is a kind of obligation on national regulatory authorities. Next slide, please. Okay, so we change approach. Now we go on what AGCOM has done and is doing in this field. As I saw, we started in 1997, in fact, according to the law 249/97, which was the law which created AGCOM. One of the tasks which were listed in this law was that the AGCOM had to ensure that the audience measurement systems had to comply with the criteria of methodological correctness, transparency, and certification by independent entities. And that this kind of measurement systems had to be carried out by bodies with the utmost representativeness of the relevant sector. And AGCOM had to issue relevant guidance to ensure compliance with these principles. Next slide, please. In case of no compliance with these provisions, AGCOM could issue either a formal warning or impose sanctions up to 100% of the turnover. Next slide, please. Then we go to more recently history. AGCOM issued two regulations providing binding guidelines to national audience measurement system. The first one was Resolution 8506 in 2006, which provided some general principles on audience measurement providers, indications on providers' corporate governance to guarantee maximum accessibility and a bigger representativeness of this corporate governance. And it also stressed on the transparency regime. Next slide. Then we go to 2021, where AGCOM provided some other recommendations for audience measurement providers, where one was to adopt the model of EGTA, which was considered the most, I would say, favorable model for measuring audience, to ensure that all the phases of the process of collection and processing of the research are auditable and replicable by an independent third-party certified body, and to ensure quality and non-discrimination of all relevant stakeholders, irrespective of the means of platforms measured. Then we go what I was saying at the beginning about comparability. We were one of the few, because this was also part of the survey that we distributed to the different NRAs in Europe, just to understand on this point on if there were cases, or they had tackled some cases in their experience on data comparability from two different audience measurement providers. In Italy, as I said, audience ratings, audience measurement is also a crucially important element because it is tied to the determination of the distribution of revenues from the sale of sports audiovisual rights among Serie A clubs. We in 2021 we had results from two different measurement systems. One was Auditel, which was based on their panel. And the second one was, I would say, kind of proprietary measurement system for DAZN Nielsen, which was a sensory-based measurement system through SDKs. Next slide, please.
Yes, Roberto, sorry to step in. This is very interesting for the discussion. But I have to ask you to go to the conclusions because we are running out of time.
I am almost finished. So we had this resolution 1822, which concluded that we had the measurement had to go through the certified body, through a GIC. Next slide, please. We tried to measure what was in terms of comparability, the difference between the two measurement systems by introducing quantitative indicators. And we discovered that the difference between the two measurement systems was up to 50%, in the sense that the figures, the numbers given by DAZN Nielsen were 50% higher than the data coming from audited. We also concluded that even if we listed several factors which could be the base for the difference, the total couldn't overcome 10% and had to be on a statistical base, and not a kind of absolute difference between the two different measurement systems in time. Okay, this is the last slide. So to conclude, so we, as I said, we participated to the EMFA board working group 3 to try to make real the application of Article 24. So this is an effort that we had to do with all the different NRAs in Italy. And we recently launched also resolutions, 199/25, with two purposes. One is an investigation, I would say, on the technologies which are used now for online platforms, I would say SDK and server-to-server mean to measure digital audience on digital online platforms. And the second one is also to verify the compatibility of current measurement in Italy with the new provision set by Article 24. This is also the second, I would say, purpose objective of this activity that we launched recently and where we are now currently occupied, let's say. Okay, so this concludes my presentation. Thank you very much.
Roberta, thank you very much. I think we can move to Conor.
Okay, thank you very much, Pier Luigi. Just before I get into things, is it easier if I share the slides or if you share the slides?
If it's easier, if you can share the slides.
If I can share them? Okay.
I have them in case you have problems, but we, Urbano and I, we have it, but it is easier because you can read.
But we'll apply an AI system in the future that will share the slide.
Hold on one sec. Okay. Now, can you all see? All good?
Yeah.
Yeah. Okay, so you can see my screen. Very good. Thank you very much for inviting me to share my perspectives on audience measurement in the European Media Freedom Act. Just before I get going, and now that I have successfully shared my slides, a word on who I am and who I'm here to represent. So I work for EGTA, which is, as has been shared, the trade body for multi-platform TV and audio businesses. You can very justifiably ask, what does that mean and who are we then? We are representing broadcasters and media service providers. So public and private broadcasters, which you're all familiar with, the likes of Media for Europe, ProSieben, RTL, TF1, and the commercial aspects of the part that sell the advertising space for those broadcasters. And hence audience measurement is crucial for what our members do. And I'm in charge of the lobbying and advocacy and the outreach to the European institutions for EGTA, which is why I am here. I've been asked to share my thoughts. We were kind of not pushing for audience measurement to be legislated in the European Media Freedom Act. We're happy that it has been. And the reason we weren't pushing is because I'm sure you're all aware, and has been mentioned by Roberta at the beginning, it's very technical. It's a complex subject. It's not an easy one to grasp. And it's certainly not an easy one to translate for regulators and policymakers to get their heads around. Roberto was explaining AGCOM's really interesting work, but I think he would also admit that not all regulators, not all the NRAs are quite as familiar with audience measurement as he and his colleagues are in Italy. Far more advanced now, and everyone is trying to get there, to understand the next steps in the process. So we have this, and there was a need following up from the Digital Markets Act, again mentioned by Roberta in her introduction, to try and see how this works with the European Media Freedom Act. When we were discussing this with the Commission when they were drafting, we were very keen to emphasize that this article needed to be built on principles and also to be sort of flexible enough and future-proof enough to work in parallel with how industry is moving forward when it comes to audience measurement. As you've heard many times already today, JICs, joint industry committees, and the term self-regulation. So audience measurement has existed for a long time, for many, many years, along the kind of path with sort of acceptable industry standards. The joint industry committees are made up of advertisers, media agencies, publishers, and broadcasters. They agree on a currency, and they agree on the methodology and how that will be audited, and they engage a measurement company to do the audience measurement. But things have changed. The system has evolved, or the media system environment has evolved, and there are gaps in the system, and there are gaps in audience measurement now. All players, to the extent that they can, are trying to maneuver and to try and evolve and to try and figure out how best to get towards some sort of cross-media measurement standards to represent and to better reflect how media content is consumed these days. So the EMFA is a good sort of arching rulebook for those. But for us, in combination with the other broadcasting associations, the European Broadcasting Union representing public service media, and the Association of Commercial Television and Video on Demand, VOD, ACT, excuse me, we felt that while the EMFA is very much a step in the right direction, if you look at Article 24, it's not entirely clear what you should do next, how you should actually regulate this, and how the actors who are being regulated should they proceed? Because we have a lot of fairly sensible terms, a lot of very sensible recommendations, but not much of a sort of, let's say, roadmap or a checklist, a blueprint as to how to go forward in order to translate these principles into tangible benefits for the broader ecosystem. So we think it's important that we utilize some of the tools that are mentioned in Article 24. Both Roberto and Roberta mentioned that we have the rules in Article 24, 1 and 2, paragraphs 1 and 2, but then paragraphs 3, 4, and 5 give an indication as to what could be utilized, and they mention codes of conduct, but also guidelines. And we, as a broader, media coalition, let's say, we fully believe that the Commission should draft some guidelines that will allow all of those regulators and stakeholders and those who have to follow these rules understand the sort of checklist and the blueprint to go forward to comply with Article 24. Now, the guidelines mentioned in, I think it's Article 24, paragraph 4, are preceded by the Commission may issue guidelines. There's no, it's voluntary. It's not an obligatory step for the Commission. Whereas in other articles, EMFA, as I'm sure you're aware, there are guidelines that have to be drafted by the Commission. So we are conscious that the Commission will have to address the other guidelines that they are required to draft before they can get around perhaps to these ones. But we would implore them to do so as soon as possible, because that will allow for Article 24 to have some meaningful impact. There, I've just put down on the screen the 7 principles and how we think and what they should mean, because they're just words. They're not defined anywhere in the text. All of those 7 principles, all of them make sense, but without some sort of, let's say, meat on the bone or some sort of blueprint. I keep repeating that term because we need to have some direction to what transparency may mean. And I'm not going to read all of these for you now. We just think that they're essential for good audience measurement, and that the guidelines that we would, again, recommend strongly that they should set out what these principles mean in practice for the different measurement systems. And we agree with all the principles, by the way. We think that the correct terms and the ones that should be doing. Maybe a couple of words. Roberto focused on comparability, and we agree that that was a necessary inclusion in the final text of EMFA. There's another principle that I think probably underlines everything else, and that's verifiability. Without the data being verified by an independent entity, it's very hard to take it at face value and to take it seriously, and that kind of underpins the whole system of audience measurement. So I think if there is one principle that may be considered slightly more powerful than the others, we would lean towards that one. And that without that principle being followed, the rest may suffer to a certain degree. But then how do you translate such principles into practice? Here, I think we need some basic systems to follow. And we want to avoid, of course, overprescription, but a certain degree of directions and rules should apply. So these are certain tools. Again, standardization, and what we would like to see in the guidelines is some basic rules around the use of SDKs, the reliance on independent panels, rules to assess invalid traffic, verifying that services reach the correct audiences across the different media and platforms. Then we move on to accreditation. And there it's all about filling the space that unregulated entities may exploit, provide certification for accreditation. And then auditing, that's by independent entities. An audit should be carried out on a regular basis. And then a word on how all of this data should be handled, because the proper handling of data processing and transparency is crucial to all of this, and to maintain some form of a level playing field amongst all the actors that are included in Article 24, and to ensure accurate audience metrics and results. Combining different data sources should be subject to certain basic requirements. So the mixing of audience measurement data with external sources of data and without the intervention of an auditor should be restricted. There should be certain transparency obligations. There should be some flagging systems introduced, and there should be a mutual exchange rule when it comes to reciprocal data sharing, whereby online platforms requesting data from independent measurement systems must in turn contribute their own data in order to have a fair pool for all of the actors involved. When we were, we keep on saying, or at least I do, that audience measurement is quite a complex and technical area. It definitely is. And one of the notions introduced by the European Media Freedom Act was proprietary measurement systems. This isn't something that was sort of, let's say, common terminology amongst audience measurement practitioners prior to the adoption and the negotiations around EMFA. So it's a new term that has been introduced in the Media Freedom Act without sort of real kind of understanding. It's not quite clear. There are attempts to explain what we mean by what is meant, by proprietary audience measurement systems in the recitals. Generally speaking, as a rule of thumb, it has been already mentioned, I think, if you follow accepted industry standards such as joint industry committees, media owner committees, where there is a system of checks and balances, where there is independent verification, and where there is a mature system of measuring that is agreed by all panels, then you are probably not a proprietary measurement provider. If, on the other hand, you aren't part of an industry standard, you're not part of an industry committee, and you do not share already how you come to the data that you get to, and that you don't share your methodology, then you are probably a proprietary audience measurement system. And we would include in that online platforms, certain telco operators, certain OTT services, and certain connected devices, that they should most definitely follow the rules in Article 24.2 in particular. But excluded from that are those media service providers who follow the existing Joint Industry Committee and Media Owner Committee principles, and also relating to their own internal purposes, relating to their own content. There's certain data sharing obligations as well. This is related to the second half of paragraph 24.2, and how we ensure that the data is actually shared correctly. It remains, again, this is another one of the art. I mean, it's one article, and there's a lot of vagueness within. And EMFA doesn't really expand on how providers of proprietary audience measurement systems, excuse me, quite a mouthful, should provide access to the results and the scope of the data included in those results. So we have a few recommendations that we believe should be put in the guidelines moving forward. So first, the regulation doesn't address the potential costs that providers of proprietary audience measurement systems may charge for the results. And in our view, that data sharing in this context should take place in line with standard or usual market practices. So if it's not free of charge, it should be at a non-discriminatory and fair market price. And if a price is applied, it shouldn't render the right of access to data ineffective. Secondly, the Media Freedom Act doesn't clearly define the types of audience data that proprietary audience measurement systems are required to share with media service providers. It mentions information on audience measurement results, including non-aggregated data. Media service providers need aggregated and non-aggregated data for a comprehensive understanding of their audience and the reach involved. Thirdly, for media service providers to effectively utilize audience measurements provided by the proprietary systems, access to these measurements shouldn't be overly complicated. We need to keep it as usable as possible. Next, the guidelines should clarify that providers of proprietary audience measurement systems are only required to supply media service providers with the metrics relevant to their own service. So it's around the content, their own content that is displayed on the platform, let's say. And the guidelines should stress that data sharing obligations don't supersede licensing agreements between media service providers, because they may have specific data sharing provisions already within them. That's more or less our ideas on the next steps to really translate these very sound and very much well received ideas into real practice, so that we can move forward to have an immediate benefit from the audience measurement rules in Article 24. Just one last word that with regard to the DMA and the provision there, Article 6.8 and 6.10 of the Digital Markets Act. Clearly, the main difference is that those rules in the DMA apply only to the 7 gatekeepers and not to anyone else. So the big difference here is that the Article 24 applies to all actors involved, and specifically to all online platforms, via the meaning of what an online platform is in the Digital Services Act. And also Article 6.8 and 6.10 in the DMA are very much in terms of access to data and data sharing exclusively. The EMFA articles go a bit deeper. It's about the methodology as well. Combined, they should have a very meaningful and positive impact to the whole market. So that's the end of the slides. I'm going to stop sharing now, and hopefully then we can smoothly transition back to there. Is that okay? Thanks very much for your time. Thank you.
I think we can open the floor for a discussion, both on, I think you are in the position, if you want to intervene, to open the floor. Urbano, people can intervene, no? Directly. Yeah, we are in the workshop modality, no?
Yeah. We can start the Q&A. Anyone can ask questions.
Okay.
Peter Matzteller.
Yeah, thank you very much. I would indeed like to take the opportunity to react to a couple of things that I heard on this very interesting topic, and to probably also share a bit how we at Netflix see this. I'm Peter Matzneller. I'm working for Netflix for the European Affairs team. I previously spent a couple of years working with the German media regulator, also dealing with audience measurement there. So I'm now seeing it a bit from the other side. Yeah, I liked what we heard on the scope of Article 24 EMFA. I think for us as a in the meantime, I would say traditional media service provider with a very clear business model of having our own editorially curated content. For us, it's extremely important that we are very clear on the scope of Article 24, that it's addressing online platforms as the ones measuring third-party content, and that the obligations that we have in the transparency obligation that we have in the Article 24 are there to that then media service providers are benefiting from them. No, like those are the ones that are being measured by other platforms, and not the ones that are targeted with the transparency obligation. So I liked what Conor was saying. This distinction is important because of course we are doing our own internal measurement of what we have, because we need that. But we are not the ones that are providing a proprietary audience measurement system. I think this is indeed important, that we also have heard this from the European Commission. Unfortunately, I would say not in writing. That's why what Conor was saying. I think guidelines from the European Commission would indeed be very helpful, because then they could probably be indeed a bit more clear about what they intended to do with the EMFA when they proposed it. During the discussions in the trilogue and in the legislative procedure, we saw that the Parliament indeed wanted to explicitly add media service providers amongst the group of adversaries of the norm. That did not go through, I think, for good reason, because the Commission was very clear in saying, no, we have platforms on the other hand, and we have media service providers on the other hand. We need to keep this distinguished. So I think every clarity we would get on that end would really be helpful. At the same time, we as Netflix, but also I can share what we discussed within the VOD coalition that we have, our trade associations in Brussels. We as media service providers, of course, we have a genuine interest in having our content measured by an independent entity. Like we at Netflix, we are now active with an advertising tier in 5 European markets, and in nearly all of them, we are step by step joining those jigs because we really value the benefits of having this type of externally created currency by a trusted third-party partner. So including, we are active in Italy with an advertising tier, and there we are very closely aligning with AGCOM and very closely following what AGCOM is doing also within the European Board for Media Services. I really appreciate all the efforts that are going on there, because it's indeed important. And then finally, this has also been addressed by before, what I heard about the technicalities of the measurement. I think from our perspective as a globally operating company, being available in all the countries of the European Union, is very important to have all the requirements as technological neutral as possible. So when we are seeing the focus on those software development kits, those SDKs, we are a bit hesitant, because we believe that some other measurement tools like server-to-server communication is equally reliable, or is equally able to reliably produce data, is a bit more modern, is a bit more privacy compatible. It's also more sustainable, and that's where I would like to make reference to the study that the Università Politecnico di Milano did very recently, where they clearly found out that there is no intrinsic technological limitation that would prevent this more technologically neutral approach with server-to-server tools from meeting the same standards that SDK would produce, and in particular would still be in line with the guidelines that AGCOM is requiring. So that's a bit our very own ask, whatever regulators, be it locally with AGCOM or also within the European Media Board for Media Services, or then when the Commission is probably dealing with it, to keep everything that we are doing as open as possible to allow for different tools that are equally functional. Thank you very much.
Thank you, Peter. Luigi, can you wait a second? We'll give the floor first to Giacomo Mazzone that asked through the chat before. Giacomo. Yeah.
Okay. Can you hear me? No. No, I don't want to intervene on myself, but I want to share with you some phrases that Roberto Viola, Director General DG Connect, made in his opening speech at Eurovisione last week, especially on the topic of transparency and standards on measurement audience. He says that EMFA forecasts a series of measures that are aimed to promote specific standards for audience measurement. And this is needed because trying to rebalance the power between all stakeholders. I'm translating from Italian, so this is why it's not perfect. EMFA forecasts a series of measures on transparency, and the Commission want to adopt standards and guidelines. So this is an answer to what has been mentioned by previous speakers, that the Commission want to intervene in that. But the Commission will intervene after having heard with attention all the things that the audiovisual sector will tell us. And we are eager, he says, to receive contribution from your sector in the next months. Article 24 of the Media Freedom Act imposed to all providers of measurement system to guarantee that the system and methodology are non-discriminatory, comparable, and verifiable. And these are not only words, but the Commission will check that to the words will follow concrete facts. He made the consideration saying that in the last years, the audience measurement practices that were stable over the last decades has been reshuffled by the new providers through the internet platform that have changed the level playing field. So now the matter is to re-establish a new common level playing field. In this sense, and this is the last phrase, not only the EMFA, but also the Digital Market Act is important. It's mentioned that there are two tools that need to be used, because Digital Market Act deals exactly with the rebalancing of the different power on the field, and is very eager to ensure transparency, equitable, and efficient measurement system, and impose to the platform, to the very large platform, the gatekeepers, to provide to the all the stakeholders, in particular to the audience, to the advertising buyers and to the publishers, transparent data and real-time measurement of the audience. The scope of the Commission is to break down the black box of the metrics that are only run by platform, and to allow a verification, an independent verification of the reach on the engagement that will happen across the various campaigns. I think that there are some answers to the question that have been raised before. Thank you.
Thank you, Giacomo. I think Roberto will be happy that you forward this position. But let's move to Luigi, that is also from the committee. Luigi Malferrari, also from the Commission. It's Luigi.
Thank you, Pier Luigi. Many thanks to the three speakers. Really very interesting talk. I've learned a lot. I will have three questions. One
Luigi, we
is,
cannot hear you very well. I don't know if it is just me.
It's a bit low, Luigi.
yeah. If I speak up, is it better now?
Yeah, try.
Okay, let me then switch. Sorry, let me then switch type of. Just a second. Is it better now?
Yes.
Okay, super. So many thanks to all the three speakers. Very interesting presentations. So I have one question to Roberto and two questions to Conor. So my question to Roberto is AGCOM going to do procedures and possibly even fine the undertakings responsible for audience measurement systems if they do not comply? And then my two questions to Conor. First question is about the proposition that he put forward at the end of his presentation, that data sharing obligations should not supersede licensing agreements. If you could please build on that and also explain why, both in terms of economic rationale and in terms of legal reasoning, this should be done in this way. And my second question to Conor is, so you mentioned the importance of guidelines. We know, however, that guidelines are not binding as such. So it will be really for judges, for competent authorities and for judges to say what Article 24 exactly means in practice. Are you going to, are you planning or are you envisaging the possibility to file some complaints with the national competent authorities or to do strategic litigation before national courts, which of course then have the possibility to refer a question to the European Court of Justice? Thank you.
Let's see if there are still other questions from the audience. If not, we'll go back to our speakers. By the way, while you think for a second, I would add the question for Roberto De Martino. Can you explain a little bit better the inquiry by AGCOM on the difference between Auditel and DAZN on a technical basis? What was the, because it looks like an interesting experiment respect to what we are discussing now about the differences and the way to look for a sort of standardization. So it's something that we may learn more if you tell us a little bit more about the technical differences. But I see Roberta a second before.
Yeah.
No, let's hear the answers.
We go for the answers. Okay, then Roberto, go.
Okay, so I am answering to the question from the previous speaker. Okay, but in general, if I understood well, you were asking if AGCOM could in the future impose sanctions or on providers which do not respect the AGCOM provisions in terms of audience.
Not the AGCOM provisions, Article 24 of the EMFA.
Okay, as I said before, we are now currently making an investigation where we have two objectives. The first one is to inquire, I would say, on the new technologies which are emerging now in this field in order to better understand what are the principles of these new technologies. And the second one is also to see if currently our previous provisions are aligned with Article 24 of EMFA. I cannot predict the future, but what I expect is that if and when the European Commission will provide more accurate guidelines of the 7 principles of Article 24 and also on the other provisions, probably what we will have to do is to make a new regulation trying to align our provisions with the European Commission provisions. This is what I foresee. I am working. I am thinking by my mind, and clearly, when and if these new provisions will be set up, we will have the general principles of our law, which can give power in order to impose sanctions if our provisions in terms of, in general terms of on audience measurement are not respected, to impose either warnings at the beginning or in the worst case, I would say, or best case, it depends from the point of view, impose sanctions. But that will, I think, depend also when more clarity will be done by the European Commission on the, hopefully, because there is a strange aspect in this EMFA regulation that now I have not the text with me, but I think that the European Commission said that they may issue guidelines, and all we hope that the European Commission will set up these guidelines. When these guidelines will be published, hopefully, I think there will be an effort in our case to see if the current regulatory framework of AGCOM is already including all the new aspects. And if not, as I told you, probably we will have to issue another regulation in order to make these guidelines also part of our regulation in order to respect the European Commission principles. I don't know if I was clear on that. Then I don't know if there is a second question, and if I had to also to about the comparability, the practical case that I mentioned in my presentation about the zone.
Yeah, well, that would be interesting.
No, in 2021 and 2022, we had this problem. As I said before, it was tied very strictly because in Italy we have a peculiar situation that sport rights are tied to audience measurement results for the distribution of funds to the Serie A teams. So we had to give particular attention to the results which were coming out from 2 different measurement systems. As I said before, at the time, Auditel didn't have the total audience, and what they were doing, the measurement of audience of Auditel were based on the panel, on the traditional panel, while the DAZN started to measure its own audience through SDK. We were monitoring the results from the two different measurement systems, and what we noticed was that there was a big difference. And we also noticed that this difference was enlarging in time, in the sense that in the first matches of Serie A, there were some difference, but as soon as the Italian Serie A championship was going on, the difference was even bigger. We arrived at in some matches, in single matches, with a difference of more than 50% from the two different systems. So during our investigations, we also tried to understand what were the possible reasons for these differences. We made several hypotheses, which are listed in our resolution 1822, 2022. One was due to the presence of satellite decoders, which were not, it was a pure broadcast, so they were not detected by SDK, so that was in favor of Auditel, I would say, data. We had also the case where some connected television were not detected through SDK because of the model of the technology, the operating systems, and so on. There was the mirroring case for accessing internet. There was the problem of the second homes, which are which were measured by DAZN, but not by the Auditel panel, because in the Auditel panel only the first households are measured. But we also try to quantify which could be the relevance of these factors, but we were thinking that they could explain 1%, 2% difference, but not 50% or more. Then we thought about two other factors. One was the, we go in technical now, in SDK settings, how the SDK were set up by DAZN, by Nielsen. And one was if the statistical representativeness of the audited panel was suitable to measure, I would say, DAZN a online service, not a traditional service like it was for the traditional Auditel panel. We try to ask to understand also with the because we had a big I would say procedure where we had hearings with a lot of stakeholders, DAZN, Nielsen, not only DAZN, Nielsen, and Auditel, but also several broadcasters and stakeholders in this market. But we concluded that we couldn't reach a conclusive a conclusion on that, which could explain this big difference. So we to conclude that because auditor was EGIC, was certified, open, transparent, and so on, it was more suitable to measure that zone than the other. But we couldn't understand. We couldn't. Also because for us it was very strange because both are in a way or the other statistical methods. So we were expecting to find a kind of fluctuation in the results, not a bias of 50%. So it's clear that there was something which, I don't know which of the two, but there was a heavy factor which were making the two technologies not comparable.
You, Roberta. That's very interesting and shows the difficulty and the complexity of the process that has started with Article 24. It's a very interesting example. By the way, if you or somebody of your team wants to write a short blog piece on this specific experience, could be of some interest, even if the result wasn't completely satisfactory.
Yeah, however, as I told you, everything was in the...
No, I know. If you want to summarize
the resolution, you find all the explanations that we try to
publish. Yeah, sure. Thanks.
All the data and so on. Also, if some data were confidential, so we couldn't publish the exact data.
Thanks. I want to give the floor to Conor and then to Roberta to close, because we are really closing. Conor.
Thanks, Pier Luigi. I'm just conscious of time, but also the need to answer or to give an answer to Luigi and his two questions. So I'll be very brief. So the first question was about when I said that data sharing obligations should not supersede licensing agreements. What was missing there is that it's licensing agreements between two media service providers. If there's a rare instance where a media service provider may be, for whatever reason, considered a provider of a proprietary audience measurement system, if there's no JIC in that market or something like that, and where there is, because these licensing agreements typically contain some specific data sharing provisions. So it's to close a loophole if one exists in those circumstances there. That's the reason behind that. And then if I can remember correctly, the second part of Luigi's question, or his second question, was to do with that the guidelines, of course, are not legally binding, and is litigation or any sort of official complaint, is that what will happen next? And I think we have to be conscious of where we stand in the process of enforcement here. Not all of the EMFA is rolled out. These obligations, Article 24, are officially enforced since August, so it's less than 4 months. It's very early in the process. We are in a sort of situation where we would like to see some tangible progress. The guidelines we've called for, we heard from Giacomo and he was transmitting the message from Roberta Viola. Very encouraging to hear, but I would say that we've already, as an industry, communicated to the Commission what we would like to see in terms of how Article 24 should be transposed. But we'll obviously make sure that dialogue remains as open as possible, and that we continue to impress upon the policymakers and the Commission what we need from them. If we do not see any sort of real movement in terms of filling that void where there is an unequal playing field, let's say, between how certain actors like gatekeepers or large online platforms, how they don't share some of the data, and they're not sharing the methodology behind how they come up with that data, then yes, we'll have to reconsider, and we will be in contact very much with the national regulatory authorities and the Commission to put a little bit of pressure to make sure that these rules have some actual meaning behind them. But I think right now we have to accept that it's very early in the day. So that's all I can say for now. I hope that kind of explains a little bit, Luigi, but thank you very much for the questions.
Roberta, thanks.
Yes, we're definitely running out of time, so I wanted just to comment, to thank you all, to comment on this last. I mean, we we also, as Center for Media Pluralism and Media Freedom, in our daily research and job, we should assess how these new provisions help the state of media viability and media pluralism. And this part will be very, very difficult because there are no sanctions here. I mean, it is not, we see the difficulties of the enforcement of these obligations, but I wanted also to, I see this very much depending on the the different level of involvement and of powers of the national regulatory authorities, but we will see from the guidelines. And thank you, Giacomo, for the good news. But also I wanted to just introduce another possibility, that is that in case in which there is a refusal to share obligation, to sit at the table of the Article 24, to to write this code of conduct and to participate to this process. This is also a behavior that is can be an abuse of market power. I'm following what happened in France with all the dispute on the copyright and the fact that the competition authority in France considered the refusal to negotiate as an abuse of market power. The refusal or the not involvement, I mean, we have no sanctions to enforce these obligations, but if the refusal to obey to this obligation is in a way a proof or a symptom of abuse of market power, maybe here there is also room for the competition authorities and the Commission to step in with another tool to help the enforcement of this article.
Let's conclude because we have finished the time. Thank you to all the speakers, Roberta, Roberto, and Conor. Let me remind you that the next EMFA Talk will be January 26, and we will be discussing Article 18 and 19 and their interplay with the Digital Service Act. So it's a discussion that will be somehow connected to this in many ways. And let me conclude with only one consideration. It seems to me that Article 24 is a good example of one of the characteristics of the EMFA regulation. It's an article with principles, but then it requires to be filled up with content. The only particularity is not the only article of the EMFA, but however is particular in this fact that this content needs a lot of streams of contribution, because it needs the industry, it needs the different pieces of the industry, it needs specialized operators, and it needs attention from regulators and the Commission to follow up the process. So it will be an interesting part of the process, and I'm sure we will come back to this in the future. Thank you again to everybody. Thanks.
Thank you.
Thank you.
Thank you.
Nice day.